everyone, welcome back. We're going to finish up studying chapter 7 by moving on and now talking about courtroom work groups or participants in the court system. So in the first lecture, we were going over the different levels of courts and different court terminology and concepts that you needed to understand. We talked about jurisdiction. We talked about subject matter jurisdiction. We talked about the dual court system. We talked about the specific courts that exist in each of the systems. So we covered all of that. Now we need to move on and we need to talk about the actual people that work in the court system. And these are our work group, our courtroom work groups. Okay. So that's what we're going to be studying with this PowerPoint. So for the first one, the first question I want to talk about is who are the main players in the court system? So when I say we're going to be talking about the players or the courtroom work groups, who are these people? Who are the people that have the main responsibility to function or work within the courts? Now, when you talk about the work groups, there's lots of different people that work in the courts. So you clearly have a judge who's in charge of the whole court. You're going to have a prosecuting attorney and a defense attorney. Then you're going to have or defense attorney, then you're going to have the actual defendant who's going to be there that's charged. You may have the victims that are in the audience. You will have the jurors. You're going to have different witnesses. You may have the court reporter, and then you may have a bailiff or clerk of the court. Okay, and then you could have spectators in the back of the courtroom. So these are the different people that work in the court system. We're going to look at 3 of them in much more detail so you understand exactly what they are required to do. Now, before we get there, I want to talk about a couple of things. The first one is, if I ask you about a trial, which do you think is more important? Is it more important to win? Or is it more important to seek the truth, to get to the truth? What is the main purpose for our court system? Is it to allow one side to duke it out and win over the other? Or is the whole purpose of the trial to seek truth? So kind of think about that for a minute. Well, we are what's called an adversarial system. If you've ever heard of that, that means we are the system where 2 sides are duking it out with each other. And the idea is if both parties are fighting for their side, then the truth will rise to the top and hopefully we will seek truth. Okay, but what happens a lot of times with the adversarial system is the need for victory outwins the pursuit of the truth. Now, there are some systems that when you do your project, you're going to find out that they are what we call an inquisitory system. Inquisitorial system. So they don't necessarily have 2 sides duking it out. The judge may be asking questions, and the whole thing is to just seek answers to different questions. So it may not be 2 people actually fighting it out in court. It could possibly reduce the need for to seek victory because you're really seeking the truth. But our system believes that we do get to the truth by having 2 people passionately arguing for their side. Now, we're going to look closely at 3 specific groups of professionals that work in the court system. So the first one we're going to talk about is the judge. Okay, so the judge is either an elected or appointed public official who is responsible to preside over the court and make sure the court process goes along smoothly. So that is what the judge does. They're kind of like a referee in sports. They're just there to kind of monitor the court process, the trial, and make sure it's done fairly. Okay, now, what is their primary mission? So we said mission is their goal. So what is their primary mission? To hear patiently, to weigh deliberately, and to decide impartially. These are the chief duties of a judge. So impartiality, patience, deliberance. So they are the ones kind of trying to be fair and neutral within the court process. That is their mission. Now, when we think about a judge, we want to think about what are some of the discretionary choices that judges have to make. We talked a lot about discretion when we talked about policing, but all professions in the criminal justice system have discretion. So when we think about it, what are some of the discretionary choices that judges have? So kind of stop and think about it for a second. What kind of choices do they get to make? Well, we can break them down to different steps in the process. So they have a lot of discretionary choices that they make prior to the trial even starting. Okay, so before trial, they have to decide certain things. Is there probable cause for a warrant? We talked a lot about probable cause. The judge has to determine if probable cause actually exists. Should the warrant be signed? The judge has to make a discretionary choice whether or not to sign the warrant. Is there enough evidence for electronic surveillance? Is there evidence for pretrial incarceration, or are we going to give bail? Are we going to decide bail or no bail? The judge is going to have to decide whether certain evidence can be presented at trial based on the exclusionary rule. So they have to decide what evidence is permitted and not permitted. And they may also have to accept a plea bargain. If the parties agreed on a potential plea, they may have to make the decision if that's an acceptable plea based on the crime. So these are all discretionary decisions that a judge would have to make. So think about this as one of those. Suppose a billionaire investment advisor is arrested for defrauding her clients out of millions of dollars. Should she be released on her own recognizance? Should she be released on bail? Or should you deny bail for her trial? So the purpose of bail, we'll talk about it a little bit later, is to make sure the person shows back up for trial. So they're first brought in front of you, and the charges are read, and you're the judge, and you have to decide, are you going to hold them in a jail, until trial, or are you going to let them go on their own and just hope they come back, or are you going to require them to pay some bail? Now, just as an aside, you should only deny bail if the person could harm others or is a flight risk. Those are the only two reasons you're actually allowed to deny bail. Okay, so think about this. You're a judge. What would you do? Would you give the person bail or not give them bail? And then think about why. Why would you make that choice? Okay, so what would you say if the crime was a violent crime against another person? Would that change your mind? So those are some of the things, discretionary choices that judges have to make. Now, during the actual trial themselves, they're sort of the referee for the trial. So they have to make a lot of discretionary choices during the actual trial. So you have to first, number one, want to make sure that the judge is neutral. So you as a judge has to always be neutral in the case. You can't favor one side or the other, no matter what the evidence is. Are the attorneys following the law? So you have to make sure that the laws are being followed. The procedural laws, all of the laws, are they being followed? Are the attorneys following ethics? Are they violating any ethical rules when they're conducting the trial? They may have to make determinations on objections. So if somebody objects during the trial, doesn't like what the other person's saying, the judge may have to make decisions on that and remain neutral. And then sometimes the defendant doesn't want a jury. So the defendant will ask for the judge to make the determination. So sometimes the judge even has to decide if the person's guilty or shouldn't say innocent, it should say not guilty. Okay. So suppose after a long day at trial, a prosecutor from the trial asks you to get a drink after work. What do you do? Or suppose that a defense attorney comes to your office after a long day of trial and wants to explain what happened earlier in the day during the trial. What do you think could be wrong with each of these things? So one of the things we said is you always want to be neutral, and you don't ever want to create the appearance that you're not being neutral. So that's called the appearance of impropriety. You never want to create an impression of impropriety, because that would not make you seem like you are not neutral. So be very, very careful when you make your choices, because your choices could destroy your impartiality. Now, they also have administrative roles. They have different duties they have to do just to keep the court functioning on a day-to-day basis. So they just have to run the court. They have to maintain a schedule and keep it moving and keep the cases flowing. They have to do lots and lots of paperwork. When they make a decision, they have to write down what the decision is and all of their reasons. So they have a lot of just administrative functions that they have to also follow. Okay. So let's think about judges. How are they selected? So how does a judge become a judge? There are three main ways that judges can get their jobs. They can be elected. So we said in New York, the Supreme Court down, all of them are elected. So the people just vote for who should be judge. Now, a lot of people don't like this because they don't know anything about the judges. They barely know about their candidates for president or Senate or House. So sometimes it's very hard to get people to vote for judges because they don't know enough about them. Unless you're working with them, you probably don't know anything about them. So sometimes some places they appoint them. So at the federal level, the president appoints them and they're approved by the Senate. In the state, it would be the governor that appoints them and they're approved by their state Senate. So sometimes they are appointed. And some people don't like this then because people don't have a say, but at least these people would know who is good. And then some states, Missouri being one of them, have what's called the Missouri Plan. And the Missouri Plan, has the Bar Association where lawyers belong, give a list of qualified people, and they use a merit system to only appoint people that are qualified. So that would be like a mixed plan, okay? Now, what are some of the qualifications to be a judge? What do you need in order to be a judge? You got to have a law degree. For most judges, in New York, some of the city, town, and villages don't have to be, but for the most part, you have to have a law degree. You have to be a licensed attorney, which means you pay specific licensing fees in your state and you have official license from your state. And you need to be a member of the State Bar Association. The State Bar Association is an association that governs all attorneys and kind of watches out and makes sure they're following the ethical rules. So you need these three qualifications. So that is the judge. So now let's talk about another person in the system. We have a person that works in the system who's called, or that represents the state. So somebody commits a crime. Even though there's a victim, the crime is technically what we consider a crime against the state. You're hurting the state by creating disorder in the state. So who represents that state in the criminal charges? This is what we call the prosecutor. So the prosecutor, district attorney, assistant state prosecutor, there's different names that they use. We in New York say district attorney. So every county in the whole state has one attorney called the district attorney, and they are the prosecutors. They are the ones that represent the state. Now, some people would argue that the prosecutors are the most powerful person in the system, because when you think about it, the police arrest for certain charges, but they hand those charges over to the prosecutor. And it's ultimately the prosecutor that gets to decide what the charges are going to be brought to the court. And also the prosecutor gets to plea bargain with the defendant. So the prosecutor could decide to drop the charges, to lower them. So it's a very, very powerful position being a prosecutor. You have a lot of final say over the person's lives. So that is why some people argue that they're the most powerful force in the system. Now, when you talk about a prosecutor, remember it's the attorney whose official duty is to conduct criminal proceedings on behalf of the state. So don't forget, the prosecutor doesn't represent the victim. The prosecutor represents the state because the crime harmed the state when it was committed. It harmed the rule of law, okay? So we already said that they're called state prosecutors, district attorneys, all kinds of different things. They are all elected. So if you want to become a prosecutor, you have to run for election. Generally, they serve about a 4-year term. So once they're elected, they serve in that position for about 4 years, and they usually rerun for many, many terms, okay? So they also can serve as like what we call a quasi-legal advisor to the police. So when police are getting the warrants together and they want to make sure the judge is going to approve them, they may work with the prosecutor's office to create the warrant and make sure it's a valid warrant. And don't forget, the prosecutor is also the one that has to carry in the evidence to court and prove all of the elements of the crime. So the prosecutor has the burden of proving guilt beyond a reasonable doubt. Okay. Now, Their main ethical obligation is to seek justice. This is really important. A lot of times you say, well, what is their sole duty? And you say to get a conviction. That's not true. They are there to make sure that justice is served. They serve in the justice system. So if they are analyzing the case, they receive all the evidence from the police and they feel that there is not enough evidence to go forward, then their obligation is to drop the charges. They are not ethically allowed to keep pursuing charges against somebody if they know they didn't commit the crime or if there's not enough evidence to go forward. So they are there to seek justice, not to seek a conviction. So remember that when I ask, what's the prosecutor's main duty? You're going to say, seek justice. Okay. Now, they have tremendous amount of discretion also. So we talked about police discretion, and then we talked about the judges having discretion. Well, prosecutors also have a tremendous amount of discretion. Remember, discretion is the decision-making power that they have, and they have huge discretion when it comes to charges and who to charge and who to let go. So that's what makes them so powerful. They have lots of prosecutorial discretion. So think about it. You're a prosecutor and the police bring you charges and you have to decide what to do with those charges. What are some of the discretionary choices that you get to make? Well, you get to decide whether to charge them when someone is arrested. So the police could bring the person to you and you could say, nope, I don't want to arrest them, or I'm not going to charge them and let them go after they're arrested. You also get to decide what level of crime. So just because the police arrest for one crime doesn't mean that has to be the crime that they're ultimately convicted of or charged with. So the prosecutor can change the crimes and do different lower crimes or higher crimes. They have tremendous power to choose that. And then they can decide if and when to stop prosecuting. So if they're working through the trial and they realize there's not enough here, they can drop the charges. Or before the trial starts, they can plea bargain with the defense attorneys and say, okay, if your client pleads to this, we'll only seek this sentence. So you have the ability to negotiate. So those are all discretionary choices prosecutors get to make. So let's use some of those discretion and think about it. You are a prosecutor and Joey was arrested for stealing a candy bar and he's 8 years old and the police bring him to you. Do you decide to press those charges? Are you going to seek charges against Joey? Now, Joey's an 18-year-old and steals a candy bar. Does that change your mind? So certain factors are going to affect a prosecutor's ultimate discretion. So maybe age is one of those factors. Maybe the seriousness of the crime is another factor. So does that change your mind? Would you seek charges against Joey if he was 18 years old? What if Joey's 18 years old and he robs the store at gunpoint? What about that? Do you charge for that? Why did you change your mind if you changed your mind? What discretionary factors were you considering when you thought about whether to do it? So these are all decisions that the prosecutors have to make, and what makes them so powerful, because they have this authority to make all these choices and ultimately change somebody's life depending on what and if they charge. Now, what factors then do we use to make those decisions? The seriousness of the crime. So stealing a candy bar, maybe not as serious as stealing money out of the register. Does the suspect have a criminal record? Has this person done it in the past? Is it clear the victim had real harm? Sometimes it's not that big of a deal. There's not any real significant harm. Is there strong evidence? How strong is the prosecutor's case to move forward? Is the witness willing to cooperate, or the victim willing to cooperate? Sometimes victims decide they don't want to testify in court, and it makes it very, very difficult to go forward if you don't have a victim. And what are the odds in favor of seeking a conviction? So although their chief duty is to seek justice, they're also elected. And so they want to win. They're not going to be re-elected if they don't win. So the chances of getting a conviction are going to also affect their discretionary choices. Okay, so last professional that we're going to talk about, the defense counsel. So we said the prosecutor's main duty is to seek justice and represent the state. The defense attorney is there solely to defend the person accused of the crime and to represent them in court. So our legal system is very complicated. And if we have a prosecutor whose sole job is to prosecute people, we need the defendant to have somebody of equal footing. If we're an adversarial system, both sides have to be equal in a sense, so that when they do get out in court, it's an equal battle, right? You don't want a heavyweight fighting a lightweight. It would be a terrible thing and the person would get hurt. Well, to have a defendant who doesn't know anything about the legal system going up against a prosecutor would be a very unfair thing. So we have defense counsel that are there to help the defendant through the process. Now, we said the prosecutor's duty is to seek justice. The obligation of the defense counsel is to zealously represent their client. So it's a completely different standard. It's very, very different than what you see with prosecutors. They don't necessarily care about justice. They are there to assure that their client's rights are protected. Okay, so some people say, well, how can you represent a defendant? Well, I'm not there because they're my friend. I'm there because in order to have this fair fight, we have to be equal. So I need to be there to fight on their behalf. So zealously represent your client means you have to do everything that's moral, legal, and ethical in order to help your client. Now, you don't lie and you don't cheat and you don't, do bad things. But if it's morally, ethically, and legal, then you have to do it to fight for your client. Now, so what do they specifically do? They have to investigate themselves. So you have investigators that are gathering evidence, but we can't just trust them that they are honest and that all the evidence is proper. So defense counsel has to actually go out and do their own investigations and evaluate the evidence that is brought to them. They have to prepare for trial, so they have to get ready to present the evidence in trial and raise proper defenses. They also have to negotiate. So maybe they're talking to the prosecutor and seeing if there's any plea bargain that can be arranged. And they have to explain everything to their own client. The client is not a lawyer and doesn't understand the legal system. So they have to be able to communicate all those offers from the prosecution back to their client and explain what is happening in this process. So they are kind of like the teacher or the voice of the defendant who's accused of the crime. So there's this quote that from the moment you walk into the courtroom, you are the defendant's only friend. What do you think about that? Do you think that's true? Because when you hear somebody's convicted or accused, somebody's accused of the crime, what's your sort of initial gut feeling? Well, they must have done it, right? Police wouldn't have arrested them if they didn't do it. So the only person then fighting on the defendant's half is really the defense attorney. So you may truly be their only friend. Now, how do we get an attorney? There are 3 different classifications or categories of attorneys. If you're super rich, you can just hire your own private attorney and they will represent you in court. They're expensive. They're probably $300 or $400 an hour. And so if you think of how many hours it would take to prepare for court and talk to the prosecutor and go through evidence and conduct an investigation, it's very, very, very expensive. Even small crimes are probably going to run you at least $5,000 to $6,000. If it's a significant crime, you're talking tens and hundreds of thousands of dollars because you're paying for every hour that attorney is working on your case. Now, since you're paying them a huge amount of money, they're going to be able to spend more time and energy probably on your case. But some people can't afford that. So if you can't afford it, then you go to the state or you go to the judge and say, Judge, I can't afford an attorney. So then one is appointed to you. So those are public defenders. So public defenders are hired by the county and their sole job is to represent defendants in court cases. Now some will say, oh, they're terrible. They're not terrible. It's actually a super competitive job. It's a hard job to get. But the problem is they have to take all the cases. As a private attorney, you're paid a lot of money and you can take a lot less cases the way you're paid. As a public defender, you have to take everybody that can't afford an attorney. So regardless of how many public defenders are in your office, if you have a ton of cases, you have to take all of those cases. So it's really hard sometimes to represent so many different defendants. Now, sometimes you want a public defender, but that public defender has a conflict. They know the victim, they know the witness, they know something about the case. So they couldn't be impartial and they can't represent the defense. So sometimes the judge will appoint a private attorney. So certain private attorneys will say, yes, you can appoint me and you can pay me at a lower rate. You can pay me at the state rate. That's maybe $150 an hour. And the state pays it. And so it's a private attorney that the state is paying. So that's a court-appointed counsel. Okay. Now, what is attorney-client privilege? This is a very important concept when you're talking about defendants. Attorney-client privilege is the requirement that attorneys keep all communications with their clients confidential. So if the defendant comes in and says, I killed her, you as a defense attorney cannot say anything. It has to be kept confidential. Now, just so you know, that doesn't ever happen. They lie to the defense attorneys just like they lie to everybody. And they very rarely ever admit that they did anything wrong. But if they do tell you things, you cannot disclose it to anybody else. And the purpose for this is we don't think defendants will be open and to their attorneys so that their attorneys won't be able to possibly help them properly in a court case if they can't communicate fairly. So if they're worried that their attorney is going to constantly go against them and tell the prosecutor what they say, they're not going to talk freely with their defense attorney, and then the defense attorney won't be able to accurately and zealously represent their client. So we've recreated this attorney-client privilege where the attorneys are not allowed to say anything that they heard from their client. So what about this? Leon, the defendant, is on trial for having sex with an underage girl. Leon confesses to his attorney. Can the attorney tell the judge? And that would be no, it's attorney-client privilege. What if Leon tells his attorney that he plans to do it again with another girl? Does it make a difference if you tell them after the fact or before the fact? And the courts have said, yes, it does. Okay. And then what if Leon refuses to pay his legal fees? Can the attorney now tell the judge about the first rape? And the answer is yes. Okay. So any crimes that were previously committed, the attorney cannot say anything about them. You cannot tell the judge anything. If the client is saying they're going to cause physical harm to somebody else, the defense attorney can let the police know that's going to, and they're ethically responsible to stop crimes they know are going to be committed. Okay, so if it's going to be committed, then they can report it and it doesn't violate attorney-client privilege. And then the last thing is, if the client doesn't pay you, that destroys attorney-client privilege, and the attorney then can tell what they want if they choose to. So what I want you to do is think about this attorney-client privilege, and this is your discussion for chapter 7. So read the scenario and talk about attorney-client privilege. So a little learning check, read through each of these and give them a letter. And then when you're done, stop it. When you're done, click and I'll give you the answers. So hopefully you got it right. BCA. Okay. Now, there are a few other professionals that work in the court system. So the court officer is also often referred to as the bailiff. That is the person that's going to keep order in the court and make sure that there's no problems or disruptions or anything like that. So they are like the court police officer. Then you have the court reporter, the stenographer. That's the person that types up everything that is said. That is very important because we talked about appeals. And remember, we said on appeals, there is no witness anymore. So the appeals court is just reading what happened in the lower court. So they are reading what the stenographer wrote. So the stenographer writes down everything that was said in the court. And then we have a court clerk. The court clerk is the right-hand person for the judge. That's the one that maintains the schedule or the docket of the list of cases that are coming forward. They're the ones that keep track of all the evidence for trial. They're the ones that are going to swear in the witnesses. So they're like sort of the administrative person to help the judge during the actual trial process and also to maintain the judge's schedule. There are also some people that we call non-professional. So these are people that don't work in the courts as their main profession, but they may have to come and testify at certain times. So you may have what's called an expert witness. So in certain cases, you need a professional to come and explain something that happened. So in a death case, we need the medical examiner to come and talk about who died and how they died. That's an expert witness. They have an expertise. They can offer their opinions on certain matters that they have an expertise in. But then you may have what's called lay witnesses. Lay witnesses are people that are not experts, but they happen to see the crime or know something about the crime. So lay witnesses are also in the courtroom, but they are not allowed to give an opinion. They are only allowed to testify about what they actually saw or heard. Jurors, the jurors are the ones that most likely are going to determine if the person's guilty or not guilty. The defendant themselves, the person accused of the crime, is almost always present during the actual trial. They have the right to be there and confront witnesses against them. So the defendant will always be there. And then sometimes you'll have the victim there. Now, the victim's usually not going to be sitting with the prosecutor because they are not there to represent the victim, but they will be in the courtroom. Sometimes they don't allow them in the courtroom until after they testify because we don't want their testimony to be swayed by what they hear other people say. But usually after that, then they're allowed to be in the courtroom. Okay, so what I want you to do is think about each of these players in the system. So that's your chapter 7 assignment. You're going to read through it and you're going to give me some answers on the different players in the system. Okay, now to get you thinking along that way, I just have some scenarios. So the defendant is in front of you accused of burning down a church, killing the pastor. The prosecutor has an eyewitness who saw the defendant leave the church right before it began to burn. You also are told that the defendant had attended that church in the past, but recently left because he was in a fight with the pastor. Do you give him released on his own recognizance, let him go and hope he just comes back? Do you give him bail or do you deny him bail? So first, you're the judge and you have to decide the bail issue. What are you going to do with this person and why? So it's not really a right answer, just think about it. Now, you're the defense attorney and you agree to take on an arson murder case. The prosecutor contacts you and offers to reduce the arson murder charge to negligent homicide, meaning less jail time. Your client claims that he didn't start the fire and there was someone else there the whole time, but he has no proof to back up what he's saying. Do you convince him that it is in his best interest to plead to negligent homicide because he will probably be convicted of murder if he doesn't? Is that zealously representing your client? Is it proper to represent your client and tell them to take a plea even if they're saying they didn't do anything wrong? So think about that. So now you're the judge again. You are assigned to preside over the trial in a gruesome arson homicide case. The prosecutor informs you that a plea bargain was reached. The defendant will plead guilty to arson, but not murder. Do you approve this plea bargain arrangement? So now as the judge, you have to decide, do you agree with this arrangement? Do you think it's fair to allow him to only plead guilty to arson and not for the murder when somebody died? So would you approve this plea bargain? Now you're the district attorney, so you're the prosecutor. While preparing a case against the accused murder arson defendant, you discover a witness who provides an alibi for the defendant. So you're investigating, the investigator is investigating, and they find this witness say, he didn't do it, he was with me. Do you tell the defense attorney about your discovery? Why or why not? Now, remember, your sole duty is to seek justice. If you find that there's a valid alibi, is it seeking justice if you keep trying to prosecute this person for the crime, or if you don't turn the information over? So one of the things that is very important in the system is that the prosecutor does have to tell the defendant stuff. It's called discovery, and they have to turn over what evidence is to the defense so that they can defend against it. So that is what seeking justice, turning that over. Now you're back to the defense attorney. When meeting with your client to prepare the defense in this case, arson murder case, he informs you that he did burn down another church last month. As far as you know, you believe that last month's church is still unsolved. Do you report this information to the prosecutor or police? Now, remember, we talked about attorney-client privilege. Would this even be permitted? Can you say anything? Okay. Remember, if it's for something in the past, attorney-client privilege kicks in. So now you're the judge again. You are assigned to preside over a jury trial in a gruesome arson homicide case that was widely publicized in the area. You attend the church that was burned out, but you did not know the victim that died. So you are an impartial, neutral referee. Can you preside over this case if you attend that church and know the people that were involved? Would you be neutral, or should you recuse yourself and step away from the case and let another judge handle the case? Now you're back to the district attorney. After you have successfully prosecuted the murder arsonist, you uncover evidence that the witness created the story to avenge a love affair that went sour. So your witness who said that they saw the defendant there, you find out is lying, most likely because they were mad at the defendant. What do? Do you let that witness still testify? Do you disclose to the defense about the witness? How do you handle that situation? Now, you can't lie. And you cannot let witnesses lie on the stand. So you cannot in any way ever allow a witness to take the stand and to lie. And you are required to turn certain things over to the defense. So all those things should play in your mind on what to do. And always keep in mind, your duty is to seek justice. What would be just in this case? Now you're back to the judge. The judge and the defendant in the arson murder was convicted and found guilty of murder in the second degree. You have your doubts about whether he actually committed the crime, but the jury said he did, and that they did find beyond a reasonable doubt that he was guilty. What do? You can throw the jury verdict out and let him go. Do you do that? Do you stick with what the jury found? If you find him guilty, do you give him a lower sentence? Those are all things you would have to think about. Finally, district attorney, you review the evidence provided by the investigators on a suspected arson murder case. There's an eyewitness who saw the defendant leave the church right before it burned. You were told that the defendant attended that church in the past, but recently left because of a fight. The pastor died in the fire, and they found accelerant in his home. What do you charge the defendant with and why, right? So now you have to decide the charges based on what your evidence is, okay? So those are all of the different things. So the last thing is just a little review. So if this is your scenario, fill in the blank, stop the video, and when you're ready, start it again. Hopefully you got them all right. So that's all I have. We are now officially done with chapter 7. Next week, we're going to move on to chapter 8, and we're going to go step by step in the process of the criminal justice system. What are all the different stages of the criminal justice system? So have a great weekend. Make sure you get done with the mind tap assignment, the chapter assignment, and your discussion. Keep working on your comparative studies project and your careers project, and I will see you next week. Bye.